So this is, you probably won't believe this, but it's written here. This is more kind of like Gordon Brown, Tony Blair, Labour government kind of jokery, but it's absolutely serious. It's this law. I'm going to read this out now. When you know certain enactments and acts of law and where they're relevant to be used, or if you have been using them, then this makes complete sense to certain things that you're doing as well, not just the whole justice system. This is the Constitutional Reform Act 2005, and it mainly concerns judges and the whole judiciary, pensions for judges, all manner of things and relating to the Supreme Court and so forth, right? But there is a section in it where communications, representations can be made between the Lord Chief Justice and the House of Commons, which does not disclude the Petitions Committee within the Commons, right? And there's some more sections as well. Section 138 is about the Judicial Committee of the Privy Council, which is, that is the Judicial Committee of a Privy Council. It is a judicial committee. There's judicial powers. So there's nothing stopping you from petitioning the King, the King's Privy Council, just like in the olden days. So the Appealite Jurisdiction Act being withdrawn has gotten, it says you can't, well, it was petitioning the House of Lords by petition and a prayer, which they've repealed. And now they've got this Constitutional Reform Act in the Supreme Court. But what they're not telling you is there is still the Privy Council, which is a judicial committee, which has an authority. So you can petition the King and that council. There's also something where Her Majesty takes over appointments that were usually made by the Lord, the Chancellor. I'm just about to read number 40, section 40, but I've spotted this in it, right? I've spotted this, and this is, it's one of those sections and group of provisions which can override itself. It can, like in the Local Government Act, you can have a whole page of law and then you can have one clause in it which basically effectively says that, oh, by the way, you know, all this doesn't apply under certain circumstances and criteria, usually with the use of an enactment. Now, you know, I'll give you a few guesses of which it is, you know, particularly when we start talking about, you know, statutory instruments, town and country planning, class F, through use of an enactment to fulfill a function. You know which enactment I'm going to say. Now this, look at this, Schedule 2. Schedule 2, powers to give directions. I picked this out from the contents page, right? And it's not a short act of law, this, right? There are short acts of law and there are long acts of law. But I'm competent and capable enough to look through the title contents page of enactment and pick out things that are relevant to things that I am interested in or wish to do or use. I am capable of doing that. Powers to give directions. So you can do this in court. You know, you give directions basically when you're proceeding in court, you know, if you want to subpoena something and so forth. You can also do these things called undertakings with the prosecution or an other party. An undertaking is basically get them an agreement that they're going to do something, you know. You're going to come to an agreement or make a request for them to fulfill something or get something or undertake a request, basically, right? And they decide to agree to it under the court rules. But then you've got directions. Well, the defendants can give directions to court, but we've got directions for judges here. Now, this is I hope that you're going to understand this and follow it, right? Part 1, the process, interpretation, right? Now, we do have this. This is important, right? When it says subsection 1, right, it will say in a minute when I show you underneath subsection 1, under subsection 1, you've got 2, 1 and 2, and 3, and then 3, but you've got subsection 1, and then when it says underneath it, under it, it's anything under that, right? So, part 1, process and interpretation. So, this is law, though. This is part of the law in this schedule. In this part, well, what part is it? It's in giving powers to give directions. I explained this in the Petitions Committee Standing Orders 145A, where powers to compel evidence and subpoena, right? Those are powers given to the Petitions Committee. And this is like when we give this is about giving directions, right? In this part, and this is at the highest level of jurisdiction that you can get in England, right? Probably, but you've also got the Judicial Committee of the Privy Council as well. But this is like for the major courts. In this part, designated directions, that is someone directing something or making directions is communications, steering, when you're driving a car, you're inputting directions into the vehicle, you're telling it where to go and what to do, right? General directions means, right, directions under another act. But what act? Directions under another act. Well, it doesn't say which act it has to be or not. You can have Magistrates Court Act. You could have civil procedure rules, criminal procedure rules. All of the civil procedure rules and criminal procedure rules facilitate for giving directions in legal proceedings, not discounting or discluding the Supreme Court if you're bringing a case to Supreme Court, which can hear criminal or civil matters, right? But also, it can you can say, well, right to petition, right? Right to petition His Majesty or either of Houses of Parliament. And when you're writing, a petition, you are writing directions, or when you're investigating or doing something through that act, you can make requests and give directions, but you're doing it through the right to petition. You're petitioning the House of Commons committee in legal proceedings using the right to petition, and they've got Standing Orders 145A powers to use them, so you can give directions. And I'll tell you in a minute, because the Lord Chief Justice can actually lay material to the House of Commons, which does not disclude the Petitions Committee as well. So you can actually give directions by petition to House of Commons through the Lord Chief Justice's authority and powers. And through the courts, which means if you're being prosecuted for a charge or something and using the right to petition, you can actually give directions through the power of the right to petition. Like, oh yeah, well, it's basically saying, like, all right, I need I need to do this, and we need to, we want to block McDonald's off, to make an advertisement for the petition, right? We're giving directions like, I want to subpoena some evidence, I want to put a witness appeal in the newspaper, or whatever. But don't let me fool you. Don't be misled by me. Don't let me trying to blag you or trick you or anything. Let me finish with this, right? Under another act, which are by virtue of provision in that act, by virtue of a provision in that act, not even this one, not even this whole Constitutional Reform Act, in that act, to be made or given in accordance with this part. Just this part though. This part here, and no other part of this entire act here, this entire act on the constitutional reform and Supreme Court and so forth, just this part here. But what is this part? What is this part? It is power to give directions. Powers to give directions. This part, and no other part of this entire act, right? I'm looking for the part of the act which is, law for giving directions, power to give directions in legal proceedings. This part, right? Power to give directions, only powers to give directions by virtue. So, directions under another act, the right to petition, virtue of provisions in this act, this part of this act, by provision, by virtue of provision in the act, is the right of the subjects to petition the king, writing requests. What is a petition? It is a request, right? Request them to do something, do this or do that. That is a direction, if you know what a direction is, when you are looking at one, right? Or when you write one yourself. Provisions in that act are all prosecutions and commitments for giving those directions are illegal. Whether or not Parliament agree to comply with those directions or not is a different matter. But the power to make the directions and the power of the act, the provisions that come with it. The provisions that come with the right to give directions to the Parliament are the right to petition, and the provisions that come with it are the provisions that all prosecutions and commitments against you for doing so are unlawful. Now, what you do through use of the right to petition, if someone is bringing a prosecution against you unlawfully, you give them directions to stop, to cease and desist, to withdraw, to discontinue, right? To discontinue. You give directions, like a court. I was subpoenaing some information, or I will summon some witnesses. I wish you to discontinue proceedings, right? Because they're illegal. By that provision in the act that you are giving directions through, that you have the right to give directions through. Powers to give directions. And provisions in an act which law compel. Now, if that is not relevant in the Constitutional Reform Act that is withdrawing the right to petition by appeal, by petitioning a prayer to the House of Lords, I don't know what is. But when would you need to use such powers in directions if you had a legal prosecution against you? Now, the thing is, the whole thing with the right to petition the Parliament is that, similarly to the elections petitions 1960, for example, and the Representation of the People Act, offences and crimes against election fraud is to be prosecuted at the High Court anyway, because you're petitioning Parliament for an election, just like when you're petitioning the House of Commons Parliament for a petition, right? the High Court anyway. Whether you want a Supreme Court or High Court, I'm not going to argue about at this point in time, because really the Petitions Committee is a small tribunal, because it has powers under 145A to compel evidence and summon people. And through this act, from the Ministry of Justice, from the judiciary, the Lord Chief Justice can lay representations and matters to concerning legal matters or issues or technicalities or matters raised, possibly through direct power of directions to courts, that can lay them out to the House of Commons. Therefore, once you open representation between the Lord Chief Justice and the Petitions Committee, you're opening a dialogue. Oh, this person says that he's petitioning to you and he's protected. He's giving directions to cease and desist. Can I check that he's running a petition with you? But, going by the current standards of the House of Commons, they don't let you, pick a paperclip. They don't let you pick a peanut because, they're even rejecting things that they've got imaginary standards, figments of standards that don't exist, time restrictions that don't exist in law. They don't exist by standing order. Time limits on petitions running online. There's no law. There's no law there. I've asked them, where is the law? Show me it. They don't show me it because there is none. They run on standing orders 145A. There is no time limit. There is no time limit because, what is Laura Tampon doing with her 8-month tampon tax petition backed by Theresa May and Paul Sheriff? Now, we're getting to the rest of this part because now I want you to take note when it says, under subsection 2 or subsection 1, because there's an argument that because of the right to petition and all prosecutions and commitments are illegal, by provisions in that act, when you are giving directions in law, right, in legal process, either to the House of Commons or if someone legally challenges you, like the police or any other court or CPS or anyone bringing proceedings against you, you've got the right to give directions. But you've not only got the right to give directions, you've got the power to give directions, right? And depending on what act you are using, you can give directions through different acts of law. For example, in the criminal procedure rules, you can give directions, right? I don't think anyone in the Ministry of Justice will dispute that, or the civil procedure rules, right? You can give directions because that's what the claimant can do. That's part of how it works, what it facilitates the giving of directions for proceedings. Now, overriding objectives require all parties to recognise the rights claimed by the claimant, right? Overriding objectives recognising the rights of the claimant when they claim them and supposedly putting them into effect. But by what power and what by direction are they compelled? Now, the thing is, directions given under another act, whichever act you want to, if you want to say criminal procedure rules, I'm using the right to petition. It's an act, and by virtue of provisions in the act, like it is illegal for me to be prosecuted, and all prosecutions are illegal, and commitments are to be made or given in accordance with this part. But what is this part? Power to give directions. So you got the power to give directions to Parliament in proceedings, but also those directions in that act come with provisions. And obviously, if someone is acting against those provisions, they're being misdirected. You need to give directions. You need to have power to give the directions. Now, the process. Now, this is where it gets a little bit more complicated. It is the Lord Chief Justice or any judicial office holder nominated by Lord Chief Justice with the agreement of the Chancellor to make or give designated directions, right? Now, the Lord Chief Justice is in charge of the Judicial Conduct Investigations Office, for example, but also sits in various courts. It can also, Lord Chief Justice can give direction to the House of Commons through this Act. I've read it. I'll go find that part in a minute, which does not disclude any committee of the House of Commons or primarily and most importantly the Petitions Committee, by which you might have a case with through a right to bring a case to Parliament for decision under directions you have written up, requesting that they make or change the law or whatever it is, or the directions that you would like them to have an inquiry with evidence you've submitted supported by powers. Now, so that's part 2.1. 2. The Lord Chief Justice may nominate a judicial office holder in accordance with subparagraph 1. Here, Lord Chief Justice may nominate a judicial office holder. Well, there are many judicial officers, and some have only limited or certain powers. You see, on the first page of on the Judicial Conduct Investigations Office page, it tells you all of the judicial officers which are under their jurisdiction, and it includes tribunals and committees that have judicial powers or limited judicial powers, like an inquiry chairman, right? They're under the Judicial Office of Investigations authority jurisdiction. Lord Chief Justice is in charge. The Petitions Committee are acting with powers, right? The House of Commons act with 145A standing order, 145A3 standing orders, powers to compel evidence and subpoena and summon people. They are under the jurisdiction of the Judicial Conduct Investigations Office because they operate like a small court or tribunal. That is a judicial office, a small court or tribunal, because they're under the jurisdiction of the investigation office. So it could be to make or give designated directions. Well, that means they can give directions. They can make directions and give directions to the Petitions Committee. But so can you. So can you. So can you. That's what you're doing when you write the petition. You're bringing the case under procedure to Commons. You're writing directions with provisions that apply through the Act. And so, you know, the committee, a normal tribunal for inquiry can refer any criminal or civil matters to the High Court, right? This means that there is a line of communication between the Lord Chief Justice and the Petitions Committee available for use when there are legal matters raised for petitions. The Lord Chief Justice may nominate judicial office holder in accordance with subparagraph 1. Subparagraph 1. Now, does that mean here? This is not a subparagraph. That is the opening paragraph. But even if it... Well, no, just a minute. So the thing is, the Lord Chief Justice... Hold on. Judicial office holder... The Lord Chief Justice may nominate a judicial office holder in accordance with subparagraph 1. But the thing is, if you're giving directions using enactment of law, right, and then within the Act it has provisions that you can't be held to any commitment or prosecuted, then that is law that applies and is applicable to everyone and anyone, including the Lord Chief Justice and Chancellor. Now, don't forget that part, which I'm making this claim. A, to make or give designated directions generally, or to make, well, when you're doing the right to petition, you're actually creating and making your own directions anyway to Parliament. To make or give designated directions under a particular enactment, a particular one, to make them, create them, draft them, to make or give directions under a particular enactment. Right, tell me, what enactment does it say? Which? Tell me, which enactment? Which enactment? It doesn't say. Tell me which you can't use. Give me a list of ones that you can't use. None. Give me a list of ones you can use. None. None. So what is it then? So what? So where are they? Where's the list of ones you can and can't use? There isn't one. Why? Because you can use whichever one you claim. Whichever enactment you claim, which may be relevant to any judicial matters under question or scrutiny, or where directions may be needed or required to be given. Right? Under a particular enactment. It doesn't say which one. It doesn't say which one or not which one. Powers to give directions. Make directions yourself. And not be held to any commitments, particularly by the Lord Chief Justice, because when you're writing your own directions, you're writing up your own idea of what the law should be, and get it changed to. The Lord Chief Justice will have to, follow those laws. In this part 3, the judicial office holder has the same meaning as in Section 1094. 1094. I'll look at that in a minute, but I'm going to suggest here it might include tribunals and committees, which could be the House of Commons as well. But I'm not sure on that. I'll have to go check. I've just written that down now. 1094. B. References to the Lord Chief Justice's nominee in relation to designated directions mean a judicial office holder nominated by the Lord Chief Justice under subparagraph 1 to make or give those directions. But in relation to designated directions mean a judicial office holder nominated by the Lord Chief Justice under subparagraph 1 to make or give those directions. Well, the thing is, in this part 1, designated directions means directions under another act, like the right to petition, which are, by virtue of provision in that act, the provision in that act that you can't be held to any commitments or prosecutions to be made or given in accordance with this part. Well, how you accord by this part, so in accordance with this part 1 here of this Schedule 2, how do you act in accordance with them? To start with, If you're using an enactment which has provisions of itself, any enactment, subparagraph 1 does not apply. Right. Lord Justice as Chancellor may make or give designated directions only with the agreement of the Lord Chancellor. Now, subsection 2, subparagraph 1, right, that's this, subparagraph 1, which is one where we're bringing in another act when we might need to give directions in any judicial matters or proceedings and have powers to do so. Subparagraph 1 does not apply to designated directions to the extent that they consist of guidance about any of the following. Well, when you're writing to make the law and using an enactment which has a special required provision, it's not just guidance, it's the application or interpretation of law and the making of judicial decisions. Well, a judicial decision would be a prosecution against someone, like you are guilty or you are not guilty. B would be the making of judicial decisions against you. Well, when you're petitioning the government, you don't actually make a decision. It's the Parliament that does. But you've got the right to draft up the directions, and there's a power, there's a provision in the Act, a legal order by the Parliament, that you can't be prosecuted. But that's law, statute law. It's not guidance. It's not guidance. I can tell you that. It's not guidance. That is the law. The application or interpretation of the law. Now, is it suggesting that the person giving the directions and the person writing the petition and the person who is using the right to petition cannot give guidance about how that law will be applied or interpreted? Or the application of it or interpretation. So paragraph 1 does not apply to designated directions to the extent that they consist of guidance about any of the following. Well, the thing is, right, within the right to petition, the right to write the petition and write the directions to Parliament, right, those directions are separate from the provisions within that enactment, right? So you wouldn't be giving directions. Your directions to the House of Commons through legal proceedings are, I want you to change the law and make smoking legal. And here is my evidence, and I would like to subpoena some smoking photographs and some videos, if you don't mind. Would like you to obtain those for me with powers 145A3. And, I'd like to summon some witnesses, not to say that, I know it's Parliament Petitions Committee, but you look at Tesla, just had she could, she can ask, when she had that debate, she could ask Andrew Bridgen or whoever it is dealing with it, she can give directions to say, well, I'd like, certain people to give evidence or certain things to be read out and so forth. That's why I gave directions. I gave directions to Parliament for that debate. I said that I wanted it noted that, whether or not actually it is lawful or not for the World Health Organization to override our rights. due to certain enactments, one of which is the 1700 Act of Settlement. There was another act raised in the matter, but he raised the question that he did get voiced, the question that I put, although he didn't raise the act that I raised, but he raised the question that I raised, because I wrote to the Prime Minister to demand that it be included in the debate whether or not the World Health Organization can lawfully do it or not. So the directions, subsection 1 does not apply to designated directions. That's not a provision of an enactment, that's a direction, to the extent that they consist of guidance about any of the following: the application or interpretation of the law and the making of judicial decisions. Right. Could there be anything more relevant or more specific, anything more relevant in English law and situational relevance if you believe you are being prosecuted unlawfully for directions given to Parliament by petition through the use of an enactment in proceedings to Parliament where you believe you shouldn't be prosecuted, and someone's about to make a judicial decision against you or argue in debate about the interpretation or application of that act, or even how it should be interpreted. But it says the directions. Over the directions. Well, the directions are drafted by you. You're writing the directions when you write the petition and when you make requests, right? But the interpretation of the law is not contained in your directions through the act. It is contained in the act, in the provisions of the act, which must be complied with by would-be evil judges, ministers, or councillors who may be, dealing with the matter. Now, the law, it basically, right, in the act, the law, the provision of law says you can't be prosecuted. You don't need to write the directions. You don't need to write, hey, could you please withdraw the prosecution, if you don't mind? I don't like it. No, that's a direction, right? But law is written in law. The application or interpretation of it, but not actually what the law is. So the directions of the interpretation of it. You got to be taking the P. Also, you give direction, the application. The thing is, in the right to petition, that you can't be held to any commitments, like these directions here, as well, which is the ultimate, idiosyncrasy. In this part, designated directions means directions under another act, which are, by virtue of provisions in the act, not directions, to be made or given in accordance with this part. Well, there's a giving of directions. So the power to give directions, or to write them in the petition. All prosecutions and commitments for doing so are illegal. So all prosecutions and commitments for writing the directions are illegal. All prosecutions and commitments for writing the directions are illegal, including these. This is not irrelevant to it. This is very relevant, taking into account that the previous act that this has sprung out from and appeared from is the repeal of the Appellate Jurisdiction Act by petition and prayer to the House of Lords. Subsection paragraph 1 does not apply to designated directions to the extent that they consist of guidance about any of the following. So wouldn't, another way of looking at this is, wouldn't that mean that if you're using the right to petition as your enactment that has provisions in it that you can't be prosecuted, have an order made against you, or be held to any commitments of any other arbitrary or diverse acts, then basically what it's saying is that the Lord Chief Justice and Chancellor has power to give directions, then wouldn't it apply? Surely. Wouldn't that work out that the Lord Chief Justice and Lord Chancellor's power to make directions would not apply if subsection 1 didn't apply to the act and provisions which you were invoking? Try working that one out. And it needs to be calculated and worked out through logic. In this part, judicial office holder has the same meaning as in section 1094. Right, well, I've got to look at that in a minute. Sorry, I've got down to 3.3 now. So paragraph 1 does not apply to designated directions to the extent that they consist of criteria for determining which judges may or may not, you may not, according to the law, you may, according to the law, you may not, for determining which judges may be allocated to even hear particular categories of case. Like what I've said with the elections petitions, fraud offences prosecuted at the High Court, not to be tried by common law, at least at one point, and they could only even be fined, and certain persons facilitating that, and then they did add prison to it at one point. But that's like in the 1688 Bill of Rights. There's a separate section in the Bill of Rights for elections being run fraudulently, and it does that section doesn't apply to petitioning the Commons or the House of Lords or the King. But the directions may, to that extent, be made or given only after consulting the Lord Chancellor. If subparagraph 1, if it applies, if subparagraph 1 applies, what if it doesn't apply? Subparagraph 1, what if it doesn't apply? If subparagraph 1 does apply, but the Lord Chancellor does not agree, designated directions made or given by the Lord Chief Justice or by his nominee, the Lord Chancellor must give that person, interesting that it says person there, written reasons why he does not agree the directions. Why he does not agree the directions. Oh, Lord Chief Justice. Do you believe that? I had to give it in writing. Why do you not agree directions? When you are using powers to give directions, particularly if someone's bringing illegal charges against you. And, it turns out that it's not supposed to be done through lower courts anyway. It's illegal to be prosecuted. That's not a direction, by the way. That is legislation. That is the provisions of the provisions of the enactment, right? Well, my directions are: I want the law on smoking changed, and here's my evidence. But now I'm finding myself being prosecuted for smoking in someone's, pub or whatever it is, and to demonstrate that it's not that harmful or something. And I'm here in court, but I'm showing me in the magistrate's court. I petition the king. I'm in the High Court. Where's the Lord Chancellor? Where's the Lord Chief Justice? I give directions to discontinue this prosecution as these charges are illegal. You send it to the Petitions Committee. Oh, it's nothing to do with us. We're not interested to help you. Well, I'm petitioning you about the case. Oh, I'll write to Lord Chief Justice then. Lord Chief Justice, Judicial Office of Judicial Complaints. I hereby complain the judge is prosecuting me illegally against the right to petition. I give directions to him to observe the provisions within the enactment which forbid such a procedure from taking place, and immediately give directions to discontinue to the Judicial Conduct Investigations Office regarding the conduct of this judge in the case, whereby his actions against me are contrary to law. And I request the Lord Chief Justice in the Judicial Investigations Office direct the judge to discontinue. If Lord Chief Justice has to give written reasons why not. Actually, not your, and in fact, not your caseworker. Does it say that the caseworker must give reasons? Does it say that your judicial office caseworker has to give reasons there? No? Well, it says the Lord Chief Justice has to give reasons. Now, how about the Lord Chief Justice giving reasons to the House of Commons through powers in this Act to lay representations to them? And to the House of Commons Petitions Committee, which is within the House of Commons, given to the fact that your case is with them, and they've got powers under 145A to compel witness informations and summons people anyway. And would not fall short of once opening up a representation with such committee, would open up communication over such representation, whereby the House of Commons Committee could, excuse me, Lord Chief Justice, one of my petitioners is complaining they've been prosecuted illegally. Would you mind directing the Justice to cease and desist through the Judicial Conduct Investigations Office, as we have reason to believe the procedure is unlawful, not by directions, but through the provisions of the enactment. If I dare read them and interpret them myself, if they're not self-interpretable, if they're not self-explanatory, if one even needs such directions to be able to read such provisions of one simple sentence and line in an act and provision of law, it is the right of the subjects to petition the king, and all prosecutions and commitments for doing so are illegal. Riddle me this. Where is the interpretation confusion in that line of inquiry? So this is it. Power of directions subject to the process in Part 1. Court-martialing. That is to do with armies. I'm not interested in that. Supreme Court. The Supreme Court Act, blah, 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 Lord Chancellor, submitting as to may be provided for directions in accord. Taking into account that, it's looking like that, supposed to be prosecuted in the Supreme Court anyway, and not in the Magistrates' Court, at least, or the High Court, like with the petitions, elections, fraud charges, which is to be prosecuted in the High Court, and not by common law, and it was only a fine even if you committed fraud of election, until they suddenly decided, maybe we might actually add imprisonment to that. Not too sure whether you can do that according to the claim of right in Scotland, but Civil Procedure Act 1997. Oh, that's interesting. That's not the Representation of the People Act. I think I've heard of that one a couple of days ago. Civil Procedures Act 1997. We'll take a look at that. Civil Procedures Act 1997. For Section 5 of the Civil Procedures Act 1997, practice directions. Practice directions may be given in accordance with Part 1 of the Schedule 2, or to the reconstitutional, or to the Constitution. No, this is the Constitutional Reform Act. Practice directions may be given in accordance with practice directions given otherwise than under subsection 1 may not be given without the approval of the Lord Chancellor and the Lord Chief Justice. Practice directions, or whether given under subsection 1 otherwise, may provide for any matter which, by virtue of paragraph 3 of Schedule 1, may be provided for by civil procedurals. Right, practice directions, right, so whether given under subsection 1 otherwise may provide for any matter which, by virtue of paragraph 3 in Schedule 1, may be provided for by civil procedurals. Well, the first thing that comes to my mind, I'm thinking about overriding objectives, and you can give directions in civil procedurals, particularly if you've got an illegal prosecution against you, but it doesn't say criminal procedurals either. Paragraph 3 of Schedule 1. I'll have to go back a page, and I kind of want to continue reading this. Powers of directions subject to the process in Part 1. Oh no, sorry, court martials, Supreme Court, civil procedure, directions to vary or revoke directions given by any person. The power to give practice directions in such a one includes power to vary or revoke directions given by any person. What about when you write a petition? I'm talking about disregarding them. To give directions containing different provision for different cases, different areas, including different areas. Well, that's the thing. To give directions containing different provisions for different cases, including different areas. Well, you've also got, you haven't got physical area, you've also got hierarchical jurisdiction as well. Does not apply to directions to the extent that they consist of guidance about any of the following: application or interpretation of the law, making of judicial decisions. You sure make an application or interpretation of the law when you're writing it and making up your own law. That's the thing. When you are, yourself writing law or proposing something to become the law, you're the one who's interpreting it, because you're the one who knows what it means. I want the law to be changed to so this is unlawful or this is legal. You're the person who's making the request for it to be done in a way. All right, they've got this kind of like, for varying them or even revoking them, but what about if you've written it? What if you've written the law? I have written some new legislation. I petition you to get this put through government without any varying or changes, and it's been given royal assent. Do I have the capacity to interpret that? To interpret the law that I wrote? Do I have... Wouldn't it be funny if he was in court and you were the person who proposed a bill, exactly word for word, and it got put through, and then you're in court and you're not allowed to tell them, interpret it? That would be joke. That would be joke upon joke. Subsection 2 does not apply to directions to the extent that they blah blah consist of criteria for determining which judges may or may not be allocated to hear particular categories of case. What, like House of Commons petitions under the jurisdiction of Parliament? Would be a category? Or election petition fraud? Election petition fraud that is to be prosecuted in the High Court? Would that be a particular category of case, by any chance? But the directions may to that extent be given only after consulting Lord Chancellor and with the approval of Lord Chief Justice. Well, what about the directions? It's funny because this is the joke, isn't it? Because ironically, when you if you give directions to Parliament by petition that you want some law making or changing, for example, and let's say they do it, let's say the House of Commons vote on it, and then let's say that they pass it on, it has to go through the House of Lords, then surely is it got to be approved by the Lord Chief Justice and the House of Lords, Lord Chancellor anyway, for the King to sign it off, which is further funny. In this act as well, there's something about the Queen also wanting to appoint people, not the Lord Chancellor, but I just thought I'd mention that. Courts Act 2003. The Courts Act 2003 is amended as follows. Practice directions and subsection Lord Chief Justice may, with the concurrence of Lord Chancellor, give directions. Directions may be given in subsection. Part 1 of subsection 2, guess the words. Subsection 2, for the words from may not be given to the end substitute given otherwise than under may not be given without the approval of. It does not apply to directions to the guidance for interpretation of law, judicial directions here, particular categories. Does not apply to directions to the extent. It's just kind of repeating the same thing with a bit of variation. So I want to look at this. What was that? One night. Schedule 1, Part 3, was it? The Lord Chief Justice or his nominee may make designated rules only with the agreement of the Lord Chancellor. The Lord Chancellor does not agree to designated reasons. He does not write so. They're going to say that this has got absolutely nothing to do with this, but it does. You're making it to do with it. You're making it have to do with it because you are bringing proceedings and you are using an enactment and you are having charges brought against you and you are giving directions and you get the power to give directions, and it concerns the interpretation of or application of law, but not by your direction, but through power of the enactment. And also, there's a question as to say that they don't have the power to make directions or make orders or interpret it. It's possible that there's a reading of this where that subsection 1 is not applicable at all, which means none of it's applicable, which means the Lord Chief Justice can't give directions when you have been prosecuted unlawfully, because you can't be prosecuted, and which means that, you know, none of the judges or anyone can give directions because it's illegal. There's that side of it. What was that? 19 or 191 was it? I don't know if it was oh no, there aren't 191 of them. 119. Or was it 19? Transfer, modification, or abolition of functions by order. I've written it down now and I don't know what I wrote. 19 something 7. Oh no, that's not the Civil Procedure Act 1997. Oh, it's 109. I wanted 109. 109. 109. Disciplinary powers interpretation. 109. Is it 4? 109.4. Disciplinary. Oh, right. Well, the disciplinary. This is like judicial. Well, this is judicial. Disciplinary powers. This is Office of Judicial Conduct and Investigation type area. Then, if it's disciplinary powers, judicial office means. Oh yeah. What does the meaning of judicial office mean? Judicial office means a office as a senior judge. B, an office listed in Schedule 14. A senior judge means any of these: Master of the Rolls, President of the Queen's Bench Division, President of the Family Division, Chancellor of the High Court, Lord of High Appeal, Senior Judge of the High Court. So we want to look at office as an office listed in Schedule 14. An office listed in Schedule. Table 2 appointments, where the Commission reports to Lord Chief Justice. All right. Office. Circuit Judge. Recorder. Master Queen Benches Division, Queen's Coroner Attorney, Administrative Registrar, Master Chancery Division, Insolvency and Court, Tax Master, Senior District Judge of the Principal Registry of the Family Division. District Judge, well, that might be DJ Watson. But that doesn't necessarily mean that DJ Watson, just because he's a senior judge, it doesn't necessarily mean that he's sitting in a court that has jurisdiction, like Magistrates Court. If it's a High Court or because that's a circuit, isn't it? district judge. Why can't district judge sit prosecution against a election petition fraud? Then riddle me that. Because he can't. Senior Master of the Queen's Bench Division, Chief Chancery Master, Chief Taxing Master, Chief Insolvery, Senior District Judge in the Family District Judge Magistrates Courts. Oh, right, no, we've got District Judge Magistrates Courts, Senior District Judge, Chief Magistrate, Deputy Senior District Judge, Chief Magistrates. So, these are the report to the Lord Chief Justice. See, the report to the Lord Chief Justice, which means that they have to. So if you've been prosecuting in a magistrate's court and you've been petitioning and you're saying I can't be prosecuted, they've got to report to the Lord Chief Justice. And according to that, if I'm not wrong, the Lord Chief Justice has got to give the reasons in writing to you. That's how I work this out. I don't think I'm wrong either, but I don't even think you can be prosecuted in those courts anyway. And then you would get it referred. Then surely you would get it referred to the High Court. But that's even if you can be prosecuted anyway. And then the Lord Chief Justice would have to make communication with the Petitions Committee. None of which of this happens because the district judge is not interested in the slightest, does not have the foggiest, slightest bit of interest whatsoever in the matter. At all.